His professional career was in the private equity/investment banking field, where he held an upper management position. Our concern centers on the judge's conduct during his trial. He did not allow the jury to hear full testimony from some of the defense's witnesses, and the majority of these defense's motions were denied, about 95% of them. It became evident throughout the trial that the prosecution was being given the upper hand. In my humble opinion, and with all due respect to all the panel, this was an act of great injustice and a gross display of judicial bias and misconduct. The judge's selections of the evidence he chose to review was imbalanced and unfair. And when he ended by reminding the jury that his opinion of the evidence should ultimately carry no weight, he only added hypocrisy to bias. I fully understand the severity of these charges, especially during a time when these horrible types of crimes are actually being committed.
It is precisely for this reason why I believe this type of cases should be scrutinized diligently, because, as we know, the consequences to a true victim are devastating, as are for the falsely accused. Perhaps a solution could be to set up a panel which reviews the decisions made by the judges. We believe there is too much power given to a single person in the courtroom. Unfortunately, time is constricted, so this is all I have for now. Once again, I thank the panel for this opportunity. Thank you.
Next speaker is Dr. Samuel Rieger.
Good evening. My name is Dr. Samuel Rieger. I reside in Waterbury. I'm currently president of the Melanie Eileen Rieger Memorial Foundation and chairman of the conference committee. This year will be the 12th annual conference. Will be held on April 23rd and 24th at the Department of Correction Maloney Training Center in Cheshire. I have enclosed copies, if you people have not seen this, of the sanctions newsletter, which was prepared by the Court Support Services Division after the last conference. Our story goes back to 1994. Our beautiful daughter Melanie was 19 years old, a college student majoring in social work and psychology, wanting to help people. She was brutally murdered in our house, strangled to death by her boyfriend on May 24th, 1994. We had a trial. He was convicted, sentenced to 60 years. At that time, good time existed, so that he is eligible for good time, which would reduce his sentence by about 1/3. Good time no longer exists, thank God. He has been incarcerated since the time of the crime. He is currently incarcerated at Northern Correctional Institution, which is the Supermax, for the 3rd time. He's been there for over 1.5 years. Usually it takes about 9 months to get through the program and then to go back to a level 4 prison. He's had at least 5 or 6 appeals, and this is what I would like to limit my comments to in order to save time tonight. A habeas appeal was heard about 2.5 years ago. There were 2 witnesses, his original attorney and himself, at which time he said that he believed he didn't understand why he has to serve 60 years for killing his girlfriend. That was the first time he actually admitted that he had done the crime. That was presented by a special public defender, by the way, which is costing the taxpayers extra money because they're not on the state payroll. I guess that attorney filed a petition for an appeal to the appellate court. Again, I'm not an attorney, so I'm not fluent in these matters. The judge at the time denied that, and that same attorney filed a petition anyway, and did not follow through with the paperwork. So the petition eventually was denied, and the newest petition was heard up in Rockville on October 29th. This was after we were up in Rockville in August. The prosecutor did not show up. The special public defender, another special public defender from Massachusetts, again paid additionally by the state of Connecticut, was totally rude to us. I actually went up to him after the case was continued. I handed him a copy of this, and I said to him, I just want to let you know what Melanie was all about and what we've been doing since her death. And he rudely said to me, I don't want to see this, and he threw it at a different prosecutor who was standing there and said, here, you find out all about them. And I think something should definitely be done about people like that. But in any case, the appeal was heard October 29th. Inmate number 230602 came in the courtroom blowing kisses to the few family members that were there, acted as a big shot as if everybody's here for him. And he's out of jail for a day and able to spend some time with his family. It's very difficult for my wife, Wanda, and I to experience this. It brings us back to the day Melanie was murdered. Here's a person that's been violent, that's why he's up in Northern, but yet the state risks people's lives by having to transport him from Northern for these hearings and also store him in the courthouse. At the end of this particular hearing, and again, the special public defender was totally rude, even to the judge in the case, which really amazed us. As the inmate was leaving, he turned to my wife and gave her a leer that she'll never forget and mumbled something which we didn't hear. And since that time, she's been having nightmares seeing this person with his hands around Melanie's throat as he did when he killed her. So I'm here to mention about these frivolous appeals. It's 13 and a half years since the crime. There is absolutely no new evidence. There will never be any new evidence. If they have 40 more appeals, nothing is ever going to change. Why should we have to be called back into court? And we go to court to make sure that things are done correctly. Because as a member of Survivors of Homicide, and I was president of that group for 6 years, we have seen too many things happen in courtrooms. So we have to be there. So what I'm asking you is to give us some relief from the criminal court system. We continually be abused by the system itself, just like we were abused by the crime. So I would suggest limiting the appeals to a certain number and also limiting the appeals to a certain amount of years. So perhaps 5 years, you have your appeals. If there's no new evidence, no more appeals. It would save the taxpayers money, and the staff in the courtrooms could be used to expedite justice for everybody else. Thank you very much.
Thank you. Our next speaker is Joanne Lenarte.
Hello, committee members. I spoke on Monday, and I'm not going to rehash any of that. I am also, since all this has happened, and I'm so much more aware of false allegations. I'm actually on the internet. There's FAST, False Allegation Solution Team. It's directed by Elaine Lehman out of Pennsylvania. And so I know that this is widespread, this is nationwide, and we even have people from England on this. And so I'm going to say America is no longer based on truth and justice. Today is a game that lawyers and prosecutors and judges play with our other people's lives. They start off with a trail of continuances and delays that can drag out indefinitely. This is what laymen refer to as job security, and because they make it so that we cannot get by without their services, we are subjected to high legal fees that are way out of our league. Although I provided our lawyer with a long list of witnesses, suggested motives of the accusers, concrete pictures and documents as proof that no crime was committed, he had no intention of using any of it. I found out too late that that was not how the game was played. I soon learned that most of the cases being dealt with behind the courtroom in the judge's chambers, and we were unaware of the goings-on there. The problem with this is that since you do not know what is being said, used, done, or it is harder to realize what they are not saying, doing, using, and doing. And you are led to believe that all is being done as it should be to bring forth the truth. In essence, it is our constitutional right to present a defense, and this practice denies one's rights for defense. What you aren't aware of is the politics that goes on. After the tragic, inconceivable conclusion, which resulted in my innocent son being led off to prison for a crime he did not commit, I began my crusade to find out what the real reason behind it. What I discovered was that once a prosecutor takes on a case, he has to win. A prosecutor's career path is to be a judge. If a prosecutor loses just one case, he would be considered to have made bad judgment in taking the case in the first place. This would cause him to lose the opportunity to direct his future as he had intended in the honorable role of a judge. In this case, there were pertinent evidence that was suppressed by the judge and false testimony brought in and presented as fact by the prosecutor because the real evidence didn't support his case. As I said, the judge did not allow the evidence that would have proven that the allegations were false. The claims of sexual assault were not supported by medical evidence. When the judge makes a ruling, you have to accept it, even when you know that the whole truth is being withheld from the jury. You hope and pray that they have enough wisdom and common sense to see through the lies that they are fed by the prosecution. All the while you are constantly frustrated because you realize they need all the facts to come to the right conclusion. How can they do that when they only have half the story? How can they be fair when the courtroom is full of misplaced belief and sympathy for the victims? The victims' advocates are allowed to come to court dressed in maroon shirts in support of the so-called victims. But when one of the victims' advocates went to attorney Mickey Sherman and told him that she didn't believe the girls at first, she believed the girls at first, but after sitting in on the trial, she didn't think he did it. We knew that her name was Kathy, and when we called the victims' advocates to get a statement from her, she never returned our phone call. Another thing I learned from all of this is that the victims are doubly protected by the law, based on their allegations alone. I also was told that the nurses and the police stick together under the blue code of justice and the white wall of silence. We were unaware that we started out with three strikes against us. DCF funds should not be based on size of their intake. This results in the need for them to create cases for federal funding. The police needs to investigate. They need to be trained in false allegation and how to spot them. They need to be trained on the characteristics of antisocial behaviors and what makes someone make a false allegation against someone else. In my case, the accusers filed 8, since he was sentenced and convicted, filed 8 lawsuits against me and my daycare insurance for $600,000. They knew I had $1 million liability policy. Jane Doe, Jessica Doe, and Mother Doe versus Joanne Lenardi in Stanford resulted in a declaratory judgment case in New Britain, Allstate versus Lenardi. When the judge ruled in favor of Allstate, their lawyers appealed that decision and are currently preparing their brief. Now Allstate wants to make a settlement just to get rid of the case, so they will be getting their money. Tamper-free videotaping, interrogations will prevent coercion, corruption, and abuse. Typewritten statement of confession should not be allowed, as it is not the exact words of the defendant. So-called victims versus defendants. I was sequestered from the courtroom because there was a slight chance that I might testify. But the 2 officers and the DCF worker were allowed to discuss the case in the conference room outside the courtroom before giving their testimonies. Attorney Mickey Sherman discovered a cheat sheet that the woman from DCF was trying to conceal under her thigh. It had the time that they wanted her to say that she arrived there, so that it agreed with their story. that was allowed. The judge asked that that be stricken from the record. The defense needs to be, or the victim side. I hear
I
that.
want to wrap up.
All right. One of the reasons, there was a lot of things that started where they didn't want the medical in, is because there's a whole list of other reasons why we need it in there. And you can go on and read that. But the thing that I really want to say here, and my son is innocent, and he had, if you look on the November-December docket for the appellate court, his name is number 1, and yet he's not even given a date yet. I'm still waiting on the date to be set. And everything's in there. The only thing that has happened in this case is the judge delayed the case a whole year because he wouldn't answer the memorandum of decision. It had to go to a motion to compel, to a motion to articulate, and he still never answered. And the whole thing is because the state has nothing. So they are prolonging this because they know my son is innocent. As well as I was also, because I own a daycare, I came out that I was at risk of injury to a child. So I cannot see my son, and this is almost going to be 4 years. And he's innocent, I'm innocent, and this has been a tragedy that someone should do something about. Thank you.
The next speaker is Stephen G. Erickson.
My name is Stephen with a V, initial G, Erickson is E-R-I-C-K-S-O-N. I posted the previous hearing on YouTube, and I'm posting stories on YouTube and on my blogs. The Connecticut State Police had a DUI 100 Club where there was false arrests to make numbers, and false arrests lead to false convictions. And if you're in prison, I mean, you lose your family, your job, your house, everything over lies. And if it's found out in the newspapers or through investigation that police officers or others acted inappropriately, there should be an automatic system in place where cases are reviewed. And if it was a false arrest, there should be compensation and records should be cleaned up. If the judicial system and police were effective and efficient, they'd have less power and less would be needed. When I owned rental properties in Stafford Springs, Connecticut, I suggested ways of helping kids not get involved with drugs and how to make them go right. But that doesn't give the judicial system the money needed. The federal tax dollars are paid to the judicial branch and the police for arrests, processing, restraining orders, and confining people. So if federal tax dollars is $75 per inmate per day, it's like each inmate's credit card. So put as many in prison as possible. Let's get to the history of the judicial branch. We're talking about ethics. Chief Judge Spezial questioned the state police on their investigations. There was 2 made-for-TV movies about how corrupt Connecticut judicial system was and the state police. The state police threatened the Chief Justice, and he retired rather than when the system wasn't straightened out. Chief Justice William J. Sullivan, he just violated the Constitution. I think he should have been arrested. He talked to Minnie Gonzalez during a Judiciary Committee meeting in Hartford, he talked about prostitutes, and he was trying to curry favor with the legislators, saying that, I'd be a prostitute too. I was just amazed that he would talk to it seems racial and improper that he said that. Judges, let's compare them to doctors. If a doctor sawed your leg off with a rusty saw, or took your wrong leg off, you could be civilly liable, criminally liable. Judges are not liable for basically doing anything. They can thumb their noses, they can do whatever they want. The judicial system will not improve until judges can be arrested for wrongdoing, crimes committed. If you go back, how many judges have been disciplined for anything? Very few. In the private sector, there are people that do things wrong. Judges should be reviewed on whether they have sociopathic tendencies. There should be public impact statements when somebody is to be sentenced. If this person is put away, this will affect the society this way, the individual this way, and the family this way. And so the 3 impact statements would maybe change how sentences are handed down. A U.S. Marine coming home, Stephen Merzen, with a PH. He saw police officers assaulting somebody, lodged a police misconduct complaint. He was stabbed 13 times. And when he woke up in the hospital alive, which was a surprise, he was arrested. The individual, David J. Taylor, a felon on probation, stabbed 3 people, almost killing Stephen Merzen. He wasn't even violated on probation by a judge. And there's case after case where people are just absolutely nailed for nothing. So what I'm saying is there's collusion between the police and the judiciary to retaliate against people that try to fix the system, either by going to legislators or by going to newspapers, which I went to both, trying to help my fellow man. And I went to prison. I lost $500,000 worth of property. I can't get a job. I've been homeless. The judicial system in Connecticut is absolutely ruined my life. Crimes were committed by police committing perjury, United States troopers, and the judge, Judge Jonathan Kaplan. And you can't get anybody to investigate police or judges. They just shred them. Police investigate police, judges investigate police. Judges. So if investigations are shredded, taxpayers can save the state money by shredding their own complaints. That's basically how things work. Thank you.
Right. 1984, Elgo was murdered. A guy named Thomas Law. He went to prison in 1990. He's doing 2 life sentences, 108 years. The purpose of this letter is, to the best of my ability, to express how I feel regarding this situation. I do not agree with myself or any of my family members being here having anything to do with Thomas Law. What and who he was, who he has taken from us, will never be replaced. I completely disagree in giving a DNA sample because he committed this horrible crime against my brother. Although hurt and pain of my brother's death is always there, this has brought extremely hurtful memories to my family and myself. Detectives, specialists retrieved more than enough evidence to convict Mr. Morrow. Adding to that is a sworn testimony in which all the evidence coincides with, not to mention, this is a eyewitness case. We cannot understand nor believe that this has ever come to this today. The Camilleri family hopes and prays that this does not go any further. We believe in the judicial system always has the best interests in victims and their families. I would like to thank you for giving me the opportunity to speak and once again express my family, myself as best I could. I love my brother dearly. Please let him rest in peace. My family and I have no doubt that Thomas Maurer is guilty. Thank you.
Is it Eisman?
If I could just be brief, Mr. Palmieri is not the only victim. A little background Mr. Palmieri is talking about. Mr. Maurer has filed a petition for writ of habeas corpus in Rockville. As part of that, his attorney has filed a request for a court order to have him and or his brother submit DNA samples for DNA testing against the evidence that was in the trial. Mr. Maurer has had 4 prior habeas. And I understand his claim is actual innocence, and really you can't stop that. But Mr. Palmieri is not the only victim. Primarily as a prosecutor, I do habeas corpus defense work. I defend our convictions against various claims. I have approximately 100 of them pending right now. The problem with the habeas system, the way it works right now, is it imposes an onerous condition on the victims, on witnesses, and actually in one case it almost imposed it on jurors. I have a case pending right now where a defendant, inmate, was convicted of sexual assault. He's making a claim that the victim informed her cousin that the wrong man had been convicted. It's the basis of his petition. We've done some investigation. We've spoken with the victim. She's never told anyone that. She's adamant that the right person was convicted. And yet she may be dragged from this area all the way up to Rockville to be a witness in a habeas matter. So there's a problem, I think, with the venue of all the habeas as being in Rockville. The witnesses for the cases are all here locally. And to force them all to take the hour and a half ride or so to go to Rockville really is kind of putting a burden on victims and on witnesses. I've had victims and their families dragged up. The other thing is that the perfect example is this case with Mr. Maurer. That's a murder that occurred back in 1984. And yet it's still going on. Now, I understand it's an actual innocence claim, but most of these habeas are for ineffective assistance of counsel. And we have attorneys are dead, they can't even defend themselves. We need to have a statute of limitations on habeas. We need to think about changing the venue for habeas to the court where the conviction occurred, where all the witnesses are. Thank you.
Next speaker is Bill O'Reilly.
Two quotes. I spoke Monday. First off, I'd like to provided you, I believe, with a lot of excellent material. And I would not ordinarily be providing anything else in the branch at this stage of stuff. If your first days of judgeship was after May of '95, Bridgeport, I may have seen you introduced to the court. I think it was you. You might not have. I do tell everyone I meet in this type of conversation that my witness of your proceedings, not just in my cases, you've always bent over backwards for fairness for everybody. Everyone. As such, I'm not trying to patch on the back here, except for I appreciate being able to tell you that. We're putting a lot of belief in you and this committee. And when you look up the word judge in the dictionary, your picture should be there. There's the ship. I don't know if you're still that person or not. The sad truth is I can't say that about anyone else come across. There's a couple of individuals that have 5 months. I support what I heard Monday, just briefly. No winner take all in the family relations stuff. First time I heard that, I support that 1,000%. Especially those who are just taking everything through lies and fabrications, such as in my case, no, it wasn't you, Judge Walter Pickett, 31 lies. Monday, I asked for some of my Americans with Disabilities Act protections and their branch administrative responsibilities in a couple of days. Has anybody been able to find any of that?
Provide us with material one day, and we've got more today.
Well, it took me 5 months to receive an audience with Lee Julianne a couple of years back. That employment poster I mentioned is out on the bulletin board out here, and it's got a wrong address. And I don't know that people coming up here to look for a job, and they may or may not be able to read. I'm not picking on people. A blind person can't read, so you're not effectively communicating with people. I took a 1-hour drive to Massachusetts a couple of years ago, just on a random day. Springfield had 3 courts in a block, which is, I was surprised, and that's not the purpose of what I'm talking about. 20 minutes in a randomly picked courthouse, and I was in the ADA coordinator's office. There happens to be 2 in every courthouse, so on that block there was 6 ADA coordinators. It's not by law, it's just they found that to work. So the first 6 pages that I gave you is just some of the stuff that was provided to me, and that I wasn't in the court more than an hour. And they gave me a notebook size. But I asked for policies and procedures. She looked at it funny, and she borrowed out a notebook that was about 3 or 4 inches thick. By the way, they've been sued. Not in Springfield, but the Bristol County courthouses under 88 in a settlement agreement through the United States Department of Justice, and an attorney with more physical access was ideally everything that I'm trying to provide to you. The next 8 pages are from the U.S. Department of Justice. It's just a few of the toolkit. Points out that you're in violation of federal law. The purpose of my giving you that, plus the fact that there's a checklist available. The last page, child's brain, that was in Monday's paper, one great paper. I find it interesting. I've got a lot of information over the course of these years here. But we look at not just what you're doing to the defendants or plaintiff, but the extended the family and with the children that get isolated, separated from their people. I do wish you all a happy holiday, happy Hanukkah, Merry Christmas. Thank you for this opportunity. I do want my babies back in violation. I did not receive equal protection of due process, which is clearly stated in these papers.
Chris Kennedy, the next speaker.
Hi, good evening. My name is Chris Kennedy. I run the Connecticut Civil Rights Council. April will mark my 7th year of my involvement with the court system. My life has been completely wrapped up, if not ruined, by the court cases that I've gone through. I guess to sum it up, there's three issues. One is there's far too much corruption in the courthouse. The second is that you know about it, and the third is that you're not doing anything about it. And I guess the first speaker echoed the thoughts of the people I've talked to, that they don't believe anything will be done about it. I talked to 25 people today at Rockville Court, and I told them about the hearing, and I talked to them about their experience with the court. They all agree that the court system is far too corrupt. They understand that there's a public hearing, but they also believe that nothing's going to be done about it. I think on Monday, I brought up some of the issues that I've experienced. And just, I guess, as far as suggestions go, family court is where my court case initiated. Like I said, 7 years ago, I lost my children. What I've noticed is that there's no equality when it comes to the family court system. There's an extreme bias against men. When you walk into court, men are paychecks. You are held to different standards than women are. Your motions are denied, the mother's motions are granted. Your children are taken from you. The mother gets custody, and you pay support. If there's contempt motions, you're held in contempt of court. Mother's not held in contempt of court. I mean, that has been a consistent, very consistent pattern at Rockville Court from what I've witnessed. And as of running the Connecticut Civil Rights Council, I talk to thousands of fathers, literally thousands of fathers who experience the same issue. I get about 100 emails a night. This bias is amazing. I've gotten documents from Guglielmo, Senator Guglielmo, about bias in the courthouse, custody battles, or these custody issues. 95% go to the mother, in favor of the mother. And I say, how can that be possible? Is Connecticut filled with that many dysfunctional fathers that none of them are able to raise a child? I know you can't get involved in individual cases, but it brings up an important point. I have a judge, Judge Kaplan, who runs Rockville Courthouse. And for the last 4 years, he's been targeting me specifically. If you're not getting, I guess the question is, why is he getting involved in my personal cases? I have transcripts here of him calling state prosecutors, admitting to it on the record, that I called the state prosecutor at Enfield, and I told him I don't think your case should be nollied. His general, I guess, defense or attack for judicial complaints is he labels people as unstable. And so that's what he's been claiming. Taking documents out of Rockville Court, going through the case files, removing documents from the courthouse, and driving them down to Hartford to submit them into an arrest warrant, to have me arrested because I filed a complaint against him. And he knowingly submitted these documents. He knew they were false. Documents that included a mother by accident or by computer error. They included the mother in a restraining order. And he knew it, and he wouldn't fix it. And he took those documents down to Hartford. I mean, I don't know. I mean, you're driving on an interstate highway. I think it's a federal offense. If you're calling state prosecutors and you're breaking the law, and there's some interstate wire fraud or something, I don't know. But honestly, that judge needs to be arrested. There's no way around it. He needs to be arrested. And I know Kevin Kane is on this committee, and I want to know when. When is he going to do something about it? When is he going to stop the judge? You know, this has been going on for 4 years. I mean, following me around the courthouse, parking his car in front of the driveway of the parking lot when I go to drive out at night. And he stops his car in the middle of the road. And I file a complaint with the state police. And the next thing I know, he's making statements to the state police. He's alleging that I tried to purchase, apply for gun licenses, or was trying to buy firearms. And that now the courthouses are on alert. And that all the attorneys have been notified. And all the judges have been put on notice that there's a safety threat. And so I went and talked to all the marshals, and they never heard of it. So I think if the courthouse was really put on alert, they would be the first ones to know about it. And this is just last week. I just got the transcript last week from this. And so you have a judge actively pursuing me. Why is he targeting me? Why is he targeting my family? I mean, is it not enough? He's had me arrested 3 times. I mean, I watched him pull my defense attorney out of a conference room so he could meet with a state prosecutor. And I say, when is this going to end? Or how is it going to end? You know, you have a judge who's actively, physically pursuing me. Putting marshals next to me is like sitting in the case flow office. You know, and this is, I hate to say it, but it's typical. It's typical. If you file a complaint against a judge, you run the risk of being arrested. If you're an attorney, you can be disbarred. If you're a father or a mother, you can have your children taken away from you. Any way that you interface with the court system, they can retaliate against you. And the problem is that the people know about it. I mean, you know that I've written to every person in the state, and you know about it. And I'm wondering when something's going to be done about it. Or are you just going to wait for something to happen? What's he going to do next, I guess, is the question. And they will not transfer the case out of Rockville Court. So if you turn those around into suggestions, general suggestions, of what judges should not do, I guess that could be applied to the entire judicial branch. Thank you.
Thank you all very much again for coming out this evening. I want to thank all the commission members who appeared tonight and who appeared on Monday to listen to your comments. Just so those of you who are here tonight understand, we've listened to your comments. We have transcripts which will be reviewed. We have your written materials, which we will also review. This committee's work continues, and I don't know when it's going to end, but we certainly are considering everything you've said seriously, and again, appreciate very much the fact that you've made an effort to be heard. And I certainly have learned some things tonight. Thank you, and have a good evening.
Take care. All right, let's see. Well,